started off as a good day for the Prime Minister. Inflation halved this year. He does say there's still more work to do. Might the Supreme Court be about to ruin his whole day? Wilf.
Okay, thank you so much for that, and a very good morning to everyone, to the Supreme Court here in central London, where we are awaiting the announcement from 5 Supreme Court justices as to their decision as to whether the government's Rwanda deportation policy is lawful or not. That decision was made last month. It will be announced in about 10 minutes' time. You can see on the side of your screen a live picture of the session. There are 2 cases preceding it. We will join the session live when they get to this key Rwanda policy. Just as a reminder of the background on this all, as Kay's already been discussing, the policy was initially announced 18 months ago. No planes have taken off for Rwanda, though, since. Not just 18 months ago, it was announced 3 prime ministers ago, 4 home secretaries ago, as of course a policy introduced by Priti Patel and Boris Johnson. As to the case itself, the key dates to remember: December 2022, the High Court ruled that the scheme was lawful. Then in June this year, the Court of Appeal overturned that by majority decision 2-1. The government appealed that, going to the Supreme Court, who sat to hear the case last month, and they will announce their decision within about 10 minutes' time. Alongside me here, of course, is our political editor, Beth Rigby. And Beth, perhaps worth mentioning this peril, this excitement coming into this, because the Prime Minister, nobody knows what this decision is about to be announced. These Supreme Court justices have kept it close to their chest. Yeah,
that's absolutely right. Nobody knows how they will rule. The only thing I would say about that, though, is if you speak to legal experts, the fact that the ruling has come in earlier than expected suggests that they are unified, which has brought about some pessimism in government that they might not go their way. And Suella Braverman last night, the former Home Secretary, certainly setting out her stall if it doesn't. But you're absolutely right. They do not know at this moment which way this verdict will go. And to put it in the context of what it means, this is a hugely pivotal moment for a Prime Minister who has set his leadership credentials on stopping small boats. And this is the flagship policy of that aim. So he really needs to try to get the flights off to Rwanda. The symbolism of it, if nothing else, in terms of showing the public that he is dealing with what they want when it comes to cutting immigration and cutting these illegal boats.
And we'll get to exactly what may or may not be announced in just a moment. But Beth, give us a bit more of that perspective on the timing of this all. As you said, one of his key 5 pledges. We might get to one of the other ones, which Kay said he got good news on this morning. But the announcement coming on a week where the former Home Secretary, now former, has just added a whole load of spice to the whole affair.
Yeah, to put it into context of where... Sorry, we're just walking across our camera there. To put it into context, and you can see as well protesters gathering behind us, the context for the Prime Minister is that the Conservatives want to try and fight the next election on the grounds of immigration. He's made it a key pledge, so he really needs victory today. And if he gets victory, and we put it in the context of that news on inflation, it being halved from the beginning of the year, another pledge hit today. If it goes his way, suddenly you've got a Prime Minister that can say to the public, look, my plan is working, like, stick with me. He needs to try and close the gap in the polls.
And as you mentioned, Beth, it all comes back to what they want to fight the election on. And of course, this is a case here in a domestic court, as were the 2 prior rulings that we just mentioned. But critically, these courts are interpreting a European court's ruling. The European Court's human rights and certain measures within that is what's up for debate. And even if this decision goes in his favour, it could still end up at the European Court of Human Rights, and that's what brings all of this back to a potentially critical election issue.
Yeah, and, you know, if it's victory, he can say that he is delivering on those pledges. But you are quite right that this is a moment, it doesn't sort the issue out, because if the government is successful, claimants can still go to the European Court of Human Rights and argue the case there, so they can still appeal the judgment. If the government loses, there is a whole row brewing now within the Conservative Party. The touch paper lit last night by Suella Braverman, the former Home Secretary, about whether we withdraw from the European Convention of Human Rights. Now, if you talk to government insiders about this, they will say that is not on the cards yet, that is not where we are yet. If their ruling goes against them, what might the government do? Well, it might try and pass new legislation through the Commons and have a go at that. It might try and change the treaty with Rwanda to try and offset some of the judge's concerns about the policy. But there is a massive discussion now in the Conservative Party about whether that's enough, or whether to get this policy through, the UK needs to withdraw from the European Court of Human Rights. That would then become an election issue. You can't do that immediately. The European Court of Human Rights and the European Conventions underpin many international treaties that the UK has, be that around the Good Friday Agreement, be that around devolution as well. So the Prime Minister won't want to do that necessarily, but the big unknown is he prepared to?
We should just mention, Beth, as well, we are now on to the second of the three judgments that the five Supreme Court justices are running through this morning. The next one will be the Rwanda policy, and we will, of course, join proceedings live for that. Beth, just add a little bit more about the criticism in Suella Braverman's letter last night, because one aspect of it was to say that even if this ruling today goes in the government's favour and they can start flights to Rwanda for refugees and migrants that have come here illegally, she was already criticising the government to say that the immigration bill was watered down. Break that down for us, because clearly there's some criticism there, but at the same time, if she really felt that, should she have resigned earlier? And was there a sense of sour grapes in this all?
That is what some MPs that are very unhappy with the conduct of her and that excoriating letter to the Prime Minister. You know, that's what some people are arguing. If it was so bad, why didn't she resign? Like, her allies would say, well, she was trying to fix the policy from within. But just where she is, I mean, in that letter, she says, if this court ruling goes against the Prime Minister, she said there's no credible plan B. He wasn't interested. We're back to square one. She says that he will be failing the promises to the British public. And just if you go back to kind of where the party might go in terms of this burgeoning civil war over this, you know, I've just had a message from one of her backers saying to me that there are 60 MPs in the Common Sense group and the sister group of the New Conservatives, that's the right wing of the party, and those MPs are with her on this issue of withdrawing from the European Court of Human Rights. So the Prime Minister is going to have a very big political problem here. And just, well, finally, in terms of the Home Secretary, I mean, I think there's a view from Number 10. She has a small base in Parliament. She's gone too far, you know, she's overreached, she's annoyed MPs. But, you know, her letter, I checked this morning, that letter that she sent to the Prime Minister last night has had over 30 million views on the social media platform Twitter, now X. And her supporters would say, whether you love or loathe what Suella Braverman has to say, she cuts through with the public, and she's a vivid politician that is saying what a lot of people are thinking. And she has clearly understood that this policy, migration, is where she wants to fight. And we've heard her time and time again say things that many feel are incendiary, but she feels is speaking to a group of voters, a group of Conservative Party supporters that are on her side on this.
30 million views. It was longer than most resignation letters, and certainly with more to it. I wonder if everyone read it.
Spikier.
It was spikier, certainly.
I haven't read one like that before.
No, I haven't read one. I wonder if everyone read it from cover to cover. Just very quickly, Beth, we've got about 30 seconds to the top of the hour, but it'd be interesting to see how much impact she has without the platform of being Home Secretary, because you might have said the same about Priti Patel. She makes some incursions to the government, but perhaps not all that impactful. We are just getting to the top of the hour, and a reminder to those just joining us that you are watching Sky News today, coming to you live from outside the Supreme Court. It is 10 a.m. And we are awaiting a decision to be announced by Lord Reid, the President of the Supreme Court, alongside 5 Supreme Court justices who made their decision as to whether the government's deportation scheme to Rwanda is lawful or not last month. And I'm here with our political editor, Beth Rigby. We've been discussing, Beth, about how this is one of his key 5 pledges. It is central to one of his key 5 pledges to stop the boats. And this Rwanda policy is, in fact, though, one he inherited. He inherited from a Prime Minister.
2022. It's a pretty Patel policy under Boris Johnson. You're absolutely right, yeah.
And do you think this is a policy he is going to want to live or die on, depending on what the decision is today?
Right, stop the boats. I mean, can you literally stop every boat coming over the channel? It's not really about that. I think what it's about is a Prime Minister understanding that if he wants to bring back the coalition of 2019 Conservative voters, he has to be seen to act on this. When it comes to the Rwanda policy, it's a moot point about how...
Beth, forgive me, we are going to now listen to the announcement from Lord Reid, the President of the Supreme Court.
This appeal is concerned with the Home Secretary's policy concerning asylum seekers and Rwanda. It's important at the outset to understand what exactly that policy is. It is not, as is sometimes thought, a policy of sending asylum seekers overseas while their claims for asylum in the UK are processed by the UK authorities. The Home Secretary's policy is that people claiming asylum in the UK will not have their claims decided by the UK authorities. Instead, they will be sent to Rwanda, where they can claim asylum in Rwanda. Their claims will be decided there by the Rwandan authorities. If their claims are successful, they will be granted asylum in Rwanda. If their claims are unsuccessful, Rwanda is entitled to expel them from its territory. In this appeal, the Supreme Court is required to decide whether that policy is lawful. That is a legal question which the court has to decide on the basis of the evidence and established legal principles. The court is not concerned with the political debate about the policy, and nothing in its judgment should be regarded as supporting or opposing any political view of the issues. In view of the public importance of this appeal, the court has expedited the production of its judgment and as a result is able to give judgment within a shorter period of time than in most of its cases. There is a legal rule that refugees must not be returned to their countries of origin, either directly or indirectly, if their life or freedom would be threatened in that country. That rule is called the principle of non-refoulement. One of the consequences of the rule is that asylum seekers cannot be returned to their countries of origin without a proper consideration of their claims, since asylum seekers whose claims have not been properly considered could well be genuine refugees. And as I've explained, refugees must not be returned to their countries of origin. This legal principle of non-refoulement is laid down in the United Nations Refugee Convention, to which the UK is a party. There are also provisions which have the same effect in other treaties to which the UK is a party. The UN Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment, the UN International Covenant on Civil and Political Rights, and the European Convention on Human Rights. It is therefore not only the European Convention on Human Rights which is relevant to this case, as is sometimes thought. There are other international treaties which also prohibit the return of asylum seekers to their countries of origin without a proper examination of their claims. These international treaties are reflected in our domestic law. In the first place, there are several acts of Parliament which give effect to the principle of non-refoulement as set out in the UN Refugee Convention. They include the Asylum and Immigration Appeals Act of 1993, the Nationality, Immigration and Asylum Act of 2002, and the Asylum and Immigration Treatment of Claimants, etc. Act of 2004. There is also an Act of Parliament, the Human Rights Act of 1998, which gives effect to the European Convention on Human Rights. Again, contrary to what is sometimes thought, the Human Rights Act is not the only relevant legislation. The effect of the legislation, in general terms, is to prohibit the removal of asylum seekers whose claims have not been decided to a country where there are substantial grounds for believing that they would be at real risk of refoulement. The issue the court has to decide is whether the Home Secretary's policy breaches that prohibition. For the asylum claims with which this appeal is concerned, the basis of the Rwanda policy is contained in the Home Secretary's immigration rules, which are statements of administrative practice. Under those rules, asylum claims can be treated as inadmissible if the claimants had the opportunity to apply for asylum in a safe third country but did not do so. The claimants can then be removed to any safe third country which agrees to accept them. A country only qualifies as a safe third country under the rules if the principle of non-refoulement is respected there, in accordance with the UN Refugee Convention. It is the next step which is controversial in these proceedings. That is the Home Secretary's guidance to the officials who apply the rules that Rwanda is a safe third country. That is to say, a country where asylum seekers will not be at risk of refoulement, her certificate, and also her certificates to that effect under the relevant legislation. There is no dispute between the Home Secretary and the claimants in this case as to the legal test which the court has to apply. The test is whether there are substantial grounds for believing that asylum seekers who are sent to Rwanda will be at real risk of ill treatment as a consequence of refoulement. If there are no such grounds, the policy is lawful. If there are such grounds, the policy is unlawful. It is argued on behalf of the Home Secretary that there are no substantial grounds for believing that asylum seekers who are sent to Rwanda will be at risk of refoulement. A memorandum of understanding has been entered into between the UK and Rwandan governments, which includes an undertaking that asylum seekers will not be subject to refoulement. Although the Memorandum of Understanding is not legally binding and cannot be relied on by asylum seekers, the Home Secretary says that Rwanda can be relied on to comply with it. There are financial incentives for Rwanda to comply with the memorandum, and it establishes arrangements for monitoring Rwanda's compliance. As against that, UNHCR, the United Nations Refugee Agency, has produced evidence of a number of deficiencies in the Rwandan asylum system. The relevance of that evidence is that if claims are not dealt with properly, then genuine claims are liable to be wrongly refused. And when claims are refused, Rwanda is entitled, under the memorandum, to expel the claimants to any country where they have a right to reside. The only country where most people have a right to reside is their country of origin. So if Rwanda does not have an adequate system for processing asylum claims, genuine refugees may be returned to their countries of origin. In other words, they may be subject to refoulement. In addition, UNHCR has produced evidence of a substantial number of cases of refoulement of asylum seekers by the Rwandan authorities, including during the period since a Memorandum of Understanding with the UK was concluded. It has also produced evidence of Rwanda's failure to comply with a similar agreement which it entered into with Israel. When this case came before the Divisional Court, it failed to give proper consideration to UNHCR's evidence. That was a mistake. UNHCR has unrivaled practical experience of the working of the asylum system in Rwanda through long years of involvement there, and its evidence requires careful consideration. So the Court of Appeal was right to overturn the High Court's decision and to consider the evidence again for itself. It concluded by a majority that asylum seekers who are sent to Rwanda are at real risk of refoulement, and that the policy is therefore unlawful. The question for this court is whether they were entitled to reach that conclusion on the evidence. The Court of Appeal based their conclusion on the following evidence. First, Rwanda has a poor human rights record. In recent times, British police have had to warn Rwandan nationals living in the UK of credible plans by the Rwandan government to kill them. In 2021, the UK government criticised the Rwandan government for extrajudicial killings, deaths in custody, enforced disappearances, and torture. There are also concerns about media and political freedom in Rwanda. Since Rwanda has ratified many international human rights conventions, this evidence raises questions as to its compliance with its international obligations. It's also relevant to the question whether the Rwandan courts can be expected to act independently of the Rwandan government when deciding appeals against the Rwandan government's decisions on asylum claims. Secondly, UNHCR's evidence is that there are systemic defects in Rwanda's procedures and institutions for processing asylum claims. To mention only some of the points raised, they include, first, concerns about the asylum process itself, such as the lack of legal representation, the risk that judges and lawyers will not act independently of the government in politically sensitive cases, and the fact that the right of appeal to the High Court, which has existed in theory since 2018, has never, in fact, been exercised. Secondly, Rwanda's 100% rate of rejection of asylum claims from countries in known conflict zones from which asylum seekers removed from the UK may well come, such as Syria, Yemen, and Afghanistan, although the UK authorities often find that such claims are well-founded. Thirdly, Rwanda's practice of refoulement, of which UNHCR gave over 100 examples, which continued during the period after the UK's agreement with Rwanda was concluded. And fourthly, the Rwandan government's apparent misunderstanding of its obligations under the Refugee Convention. The third matter raised is, in UNHCR's evidence, is Rwanda's failure to fulfill undertakings which it gave to the government of Israel under an agreement for the removal of asylum seekers from Israel to Rwanda, which operated between 2013 and 2018. In terms of the agreement, asylum seekers sent from Israel to Rwanda were to be allowed to claim asylum there, and there was an explicit undertaking by Rwanda to comply with the principle of non-refoulement. The agreement was therefore similar in those respects to Rwanda's agreement with the UK. Despite the terms of the agreement, asylum seekers who were sent to Rwanda by the Israeli government were routinely moved clandestinely to a neighbouring country from which they were liable to be refooled. That evidence is not contradicted. and it raises a serious question as to whether the undertakings given by Rwanda under its agreement with the UK government can be relied on. As I've explained, the legal test which has to be applied in this case is whether there are substantial grounds for believing that asylum seekers sent to Rwanda would be at real risk of refoulement. In the light of the evidence which I have summarised, the Court of Appeal concluded that there were such grounds. We are unanimously of the view that they were entitled to reach that conclusion. Indeed, having been taken through the evidence ourselves, we agree with their conclusion. We accept the Home Secretary's submission that the Rwandan government entered into the agreement in good faith, and that the capacity of the Rwandan system to produce accurate and fair decisions can and will be built up. Nevertheless, asking ourselves whether there were substantial grounds for believing that a real risk of refoulement existed at the relevant time, we have concluded that there were. The changes needed to eliminate the risk of refoulement may be delivered in the future, but they have not been shown to be in place now. The Home Secretary's appeal is therefore dismissed. There is also a cross-appeal on behalf of one of the asylum claimants who argues that the Rwandan policy is in breach of retained EU law, as well as being unlawful for the reasons that I've already explained. We reject that argument on the basis that under an Act of Parliament enacted in 2020, the EU provisions in question ceased to have effect at the end of that year. The cross-appeal is therefore also dismissed. The Court will now adjourn.
We are live outside the Supreme Court, where you just heard Lord Reed hand down the decision. He and his fellow Chief Justices had made a unanimous decision to uphold the Court of Appeal's ruling from June that the government's Rwanda deportation policy was unlawful. I'm here with Beth Rigby, our political editor, and Annette Elder, legal expert on immigration policy from the Law Society. Beth, let's get right to the crux of this. A unanimous decision to rule the Rwanda deportation policy as unlawful.
A unanimous decision, a huge blow to the Prime Minister. This policy, this visual symbolism of him tackling the small boats. The plan was to be able to put failed asylum seekers on planes to Rwanda. The visual antidote, if you like, to those images of people coming across to the southern coast on boats. It has been ruled unlawful. It's a big blow to the government. It will increase the anger from the backbenchers led by Suella Braverman that the government is failing on the immigration policy. And now the Prime Minister will have to think, what does he do next? Does he try and find other countries to try to return people to? Does he try and put something through the House of Commons? But this is a massive blow for the government today. This is a pivotal policy, the linchpin of his migration plan, and it has failed in the courts after 18 months have been announced. Still no planes going to Rwanda.
Months, no planes, hundreds of millions of pounds already spent. Annette, as I mentioned, from the Law Society, an expert on immigration policy, we were waiting for this decision. We didn't know if it would be a split decision, if there would be lots of caveats attached to it. Your reaction to a unanimous upholding of the Court of Appeal's ruling that this policy is unlawful?
I mean, the fact that it's unanimous, is a very strong endorsement of the Court of Appeal decision. And it's a really strong endorsement of all the people who have spoke out since the plan was first announced in April 22, that this was, unsafe, unjust, not lawful. Of course, it's not the end of it. the government, as Beth have said, they're not going to let this go. There'll be other things that they will think about. It will add momentum behind calls for, rethinking our relationship with the European Court. So Annette,
before we get to what comes next, and I'll come to Beth for that, just remind our viewers why they've reached this unanimous decision. It all comes down to the ECHR and whether refugees once arriving in Rwanda would have been safe or not. Just explain that a little bit more.
Very broadly, the arguments before the Court of Appeal related to the legal test around whether it was unsafe in Article 3 ECHR terms to relocate people to Rwanda. Also, the general evidence related, mainly from UNHCR, relating to the processes in Rwanda, access to lawyers, asylum interview procedures, their appellate process, whether they could protect people from ending up being returned to their country of origin and the risk of persecution. There were some subsidiary arguments around EU retained law, but the crux of it really is whether people could be safely returned to Rwanda. And a unanimous Supreme Court decision very much endorses that, all the thousands of pages of evidence that showed it wasn't safe, that Rwanda is not, their procedures are not robust enough to make these determinations, that there was merit in those arguments. So,
and Lord Reid did say towards the end there are changes to the policy that might make it possible to be enacted, but they haven't been presented yet. Maybe we'll come back to that in a moment with Annette. But Beth, there are lots of options now for the government. There's the nuclear options on the table, like trying to leave the ECHR, or there's a more nuanced one. But what's your assessment as to what's likely? What might placate the right of the party?
There are other options, but let's just pause on this. The Prime Minister stood on a stage at the beginning of January this year. He told the British public, I will stop the boats. Everyone said that is a really hard thing to deliver because there's no silver bullet. There's so much complexity around trying to stop migration in other countries where people are trying to come. Do you need a returns deal with the European Union? Well, you're not going to get one of those because you've left the European Union. How do you deal with the border on France? It's not an easy resolution. It is not easy at all. So it's already a really difficult policy. He then hung the whole thing around deportations to Rwanda. There was a moot point about whether or not the policy would be effective anyway. The permanent secretary at the Home Office back in November last year, I think, said there's some questions about whether or not this policy is effective, but the symbolism of it, because a Prime Minister going into an election needs to at least be able to say to voters, I might not have stopped the boats, but look, I am trying and I'm being foiled by the European courts, or I'm being foiled by judges and Labour aren't with me, but I am fighting for you. And the symbolism of being able to move people to a third country was what he politically hoisted all of this upon. So this is a massive blow. 18 months in, it's still not happening. And now they've got to think again. And as it might be, I was speaking to someone in government about the ECHR question. And my sense was that's not yet on the cards. They think there's things that they can do in domestic legislation first. They could try and review the treaty with Rwanda to see if they can get it through the courts. They could try and override human rights laws in the Commons. But even if they do all of that, the question is, going into an election, will they have the visibility of flights going? Even if they had been successful today, flights might have not gone until December or January. And now the whole thing is definitely grounded, and that creates a massive political problem for him with the public, but also within his own party.
And hence why the nuclear option might be on the table, which we'll come back to in a moment. But Annette, let's just explore this middle ground option, because as Beth said, the terms of the treaty with Rwanda, it's not even a treaty yet. It's really a memorandum of understanding that never went through Parliament. So we heard there Lord Reid say there are changes to the policy that could be made, but they haven't been presented yet. What are we talking about there? We're talking about making the UK Rwanda policy and treaty more legally binding on Rwanda and what it does when people arrive, and putting it through Parliament? Would that be enough in your mind, or what are they talking about there? What's the middle ground option?
I mean, I think it's important to consider the process. So the first challenge took place in June 2022. So the evidence about the situation in Rwanda is effectively frozen at that time, June 22. So it will depend what the judgment actually says, and obviously hours of time and lawyers' time will go into unpicking that now. But if it can be shown that addressing some of the concerns that led to this decision, maybe about procedures, access to lawyers, access to courts, there may be ways of sticking with much the same model, but improving the procedures that people go through. So that is something I guess the government will look at. I mean, I think really the most you can say at this stage is, all right, now we know kind of what the landscape is. What will happen next is political. And, there are ways that we could still see this plan, maybe in a revised form, going ahead.
And as Annette was just saying, I've just had this in from a former figure in the Home Office that said, let's see what happens, because the ECHR is not all the answer. EU countries are looking to follow the Rwanda scheme without pulling out of the ECHR. And this person says it's about working through individual cases within the framework of immigration law.
I think we've got the lawyers coming now.
We've got a statement coming. I'm just waiting to see exactly who we've got coming out here to make a statement. Here comes a number of people out. We'll keep the discussion going. I think we can get the boom mic and listen into this, guys. These are the lawyers, victorious lawyers, who have been, of course, fighting the government's plan, and just received that unanimous judgment we mentioned, the 5-0 judgment by the justices,
thank the Supreme
upholding
Court for its
the Court of
careful
Appeal decision
and
that the
considered
government's policy
judgment.
was unlawful.
This judgment and this victory for our brave clients who stood up to what is an unlawful and inhumane policy. Today, it's not just a victory for them, but it's a victory for the rule of law. It's a reminder that no one is above the law, and it's timely that governments are told that they have to stay within the boundaries of the law. We can hope now that our clients and many others can dream of a safer and better future. Thank you.
Where does the government go now? Because the potential is that they go back and renegotiate the deal with Rwanda or another country.
They will have to consider and read carefully what the Supreme Court has said in this judgment. The Supreme Court was unanimous and very clear as to why they were concerned and ultimately held that the policy is unlawful. They have to take into account not just the European Convention of Human Rights. The Supreme Court was clear that this country's domestic law and many other international conventions apply when it comes to the government applying or deciding whether or not they can remove asylum seekers to third countries.
Have you been able to speak to any of your clients yet about the result?
Not yet.
And February Sky News, do you think that the government's Rwanda policy is now over, that they have to think again?
Well, this current policy has been declared unlawful. The Supreme Court has effectively struck it down. We'll have to see what the government does next.
And what do you think of Swella Braverman's view that actually it would be better for the government to pull out of the ECHR in order to get this policy going?
The ECHR is one of many international instruments, one of many international conventions that make it very clear that this country, and in fact this country's laws itself, are very clear as to how that you should respect human rights of asylum seekers.
What do you think of it then? Do you think she's being, it's not workable, she shouldn't do it, they should begin to think about it?
I would say a former Attorney General and a lawyer herself should have the respect for the rule of law, and that's what the Supreme Court has held today.
Perfect. What do you think swung it for you? This case, was it the intervention of the United Nations?
The UNHCR's evidence was absolutely key, and the evidence before the court, before the Court of Appeal and indeed the Supreme Court, was very careful and very clear that there is a real risk, a substantial real risk of reformal and ill treatment if these individuals go to Rwanda. And the evidence and the UNHCR were clear throughout, and that's what the Court of Appeal and the Supreme Court has accepted.
What do you think the future is for asylum seekers now in this country?
Well, that's not for me to comment on. We can only represent our clients to the best of our ability, and it gives at least those asylum seekers some hope that this country, the highest court in this country, has confirmed that there is respect for human rights and dignity for all who come here for international protection.
Congratulations and well done. Thank you.
Just final question. Were you always confident that you were going to win this case?
No.
You weren't?
But
why not?
Well, because it's a difficult case. We were always confident with the evidence of our claimants and of the UNHCR, absolutely. We were always confident that we had a very strong case and we put it to the courts properly. But you can never be confident in a case like this.
That microphone. Sylvia, the microphone.
Thank you.
That there was
Thank you very much.
Lewis, of course, the law firm that has been fighting the case against the government to try and uphold the Court of Appeal's decision that the decision to send refugees to Rwanda was unlawful. Tawfiq Hussein there from Duncan Lewis. Beth Rigby was there throwing some of those questions to him, and still with us as well is a legal expert, Annette. Beth, you're throwing there some questions about the ECHR in particular, and getting some perspective on what might happen if the government went a step further. What was your take on what we heard there?
Well, the first point was the relief that they won the case, and the lawyer there representing those claimants saying he wasn't confident that it was a difficult case. But then when I asked him about pulling out of the European conventions, that whether or not leaving the ECHR was the next step the government should take in order to get this policy off the ground, he said he did not agree with that and spoke about the way in which these rules underpinned lots of other international treaties. The other thing, when I asked him about what he thought about Suella Braverman's report, he said, as a former Attorney General and Home Secretary, I think she should respect the rule of law. So I think there was a criticism there in a very lawyerly way, but clearly totally disagreeing with what she was saying about how the government should handle this next.
Now, Beth, I know, is eagle-eyed on getting any government response, any Labour response. We've got a bit of other response to bring you now, the Lib Dems, but first and foremost, a response from the Rwandan government, and this statement has come from Yolande Makolo, the Rwanda government spokesperson. Let me just read this to you. This is ultimately a decision for the UK government and the UK's judicial system. However, we do take issue with the ruling that Rwanda is not a safe third country for asylum seekers and refugees. In terms of refoulement, Rwanda and the UK have been working together to ensure the integration of relocated asylum seekers into Rwandan society. Rwanda is committed to its international obligations, and we've been recognised by the UNHCR and other international institutions for our exemplary treatment of refugees. Throughout this legal process, we've been busy continuing to deliver progress for Rwandans and working together with international partners to solve some of the biggest challenges that Africa and the wider world faces. We take our humanitarian responsibilities seriously and will continue to live up to them. We've also been getting, as I mentioned, some response from the Lib Dems, and Beth, other political reaction is starting to come through as well.
Yeah, we're waiting. Look, we're going to hear, I'm trying to find the Lib Dems. I'm trying to find the here. We're going to hear from the Prime Minister in the Commons at midday at Prime Minister's questions. So we're going to hear from him quite soon. We're waiting to hear from Labour. This is what the Lib Dems say. They say that it was so much time and money wasted. It was clear from the get-go that the Conservatives' Rwanda scheme was destined to fail. Not only is it immoral, unworkable and incredibly costly for taxpayers, but the Supreme Court has confirmed it's unlawful too. So much time and money wasted. It's time for Cleverly, the new Home Secretary, to get serious and get on with fixing the broken asylum system, and they say tackling the sky-high asylum backlog and creating safe and legal routes to sanctuaries, is the way to go. And I should just point out on James Cleverly as the new Home Secretary. He has publicly said, remember he was the Foreign Secretary, he has publicly said that he is not in support of leaving the the European Convention of Human Rights. Interestingly, Robert Jenrick, the deputy to him, had an article in the Telegraph saying yesterday, no ifs and buts, we are going to get this scheme off the ground. And there you see the dividing line in the Conservative Party. I mean, this just through from a senior One Nation Conservative says to me, anyone who thinks leaving the ECHR is a sensible response to this judgment has not read it. It wouldn't make any difference. So what we're beginning to see now are some of the dividing lines in the Conservative Party here about what to do next. But the government has, as I said, hoisted it has pinned its reputation and pinned the success symbolically of dealing with the small boats on this policy, and the policy has been ruled unlawful by the highest court in the land, and now they have to go back, work out what they have to do next. Just quickly, Suella Braverman said, didn't she, Wilf, yesterday in her letter, there is no plan B. We're going back to square one. I'm sure they will have a backup plan, but we now have to wait to see what it is.
Now, Annette Elders just stepped away for a moment, and we're able to bring in Enver Solomon, who's the CEO of the Refugee Council. And Enver, your reaction to this decision and, of course, the scale of it, a unanimous decision.
Extremely significant, a very clear victory, and let's be very clear about this. This is a victory for the rights of the people, men, women and children who come from countries like Afghanistan, where they've fled persecution and torture, places like Syria, where they've had to flee from devastation, from bombs and bullets, and places like Iran, where they've fled the clutches of a tyrannical regime. Today is a victory for their right to come to the UK and seek safety as our fellow human beings.
What is your response to the statement we just heard from Rwanda to say that they put in an enormous amount of work, that they consider themselves a safe third country? Actually, removing people to Rwanda would not be the same as putting them back into harm's way.
Well, the highest court in the land has looked at all the evidence and made a very clear judgment today that what they claim about their system, their asylum system being safe and being fair, does not bear up to the scrutiny given by the highest court in the land. And I think the judgment is very clear that the Rwandan asylum system is not safe, it's not fit for purpose, and that tells the story that the government should never have tried to put this deal in place. This isn't the country who we are. We're a country that believes in, I think, showing a common humanity and compassion to those who've lost everything through no fault of their own.
Just coming in, I'm just being told that a meeting is being convened right now of those. Sorry, let me just find it. Of those. Of the new Conservatives, that group around Suella Braverman, there are about 60 MPs in the new Conservatives and Common Sense group together on the right of the party. I'm not sure how many of them meeting, but I'm being told that they are meeting right now, convening a meeting to work out how they want to respond to this. It's pretty clear from what Suella Braverman said in the letter that she intends to be the figurehead of this push now to get this policy through with more robust measures as they would see from the government. As I said, on the other side of the party, they're saying it doesn't make sense to pull out of the European Convention of Human Rights. It won't resolve the problem, but by goodness me, we are gearing up for a massive battle within the Conservative Party.
And Beth, just give us a bit more perspective on that, because 1 year in, the Prime Minister decided he was strong enough to remove one or two of the balancing figures he put in the cabinet, most notably Braverman herself, bring in more centrists, most notably Lord Cameron. Is he strong enough to stand up against that fight?
Look, I think what's happened over the past few weeks is that Suella Braverman was causing the Prime Minister a problem from day one, be it on language, be it on some of the policies around the hotels. Do you remember that? That was all a massive row about whether or not that they had found proper accommodation for asylum seekers, and then the language about an invasion on the south coast and the hurricane of migrants coming. So that has all run through. And I think in the end, he decided, if she has been so insubordinate in my cabinet, what have I got to lose? Final thought that, though, I spoke to one very upset Conservative MP last night who said to me, both of them here are in the wrong, that we need Suella Braverman and the Prime Minister to come together, that we don't need this public civil war, and despair from many Conservatives that just want to save the seats, that now the whole Conservative psychodrama that Rishi Sunak was meant to put to bed is back in technicolor with the sacking of Suella Braverman.
And we're going to discuss as well how strong he is, because he did successfully get some news on one of his pledges this morning.
Yes.
But let's return now to the case, and I'm able to bring in now Sophie Lucas from Duncan Lewis, director there, the law firm that was fighting the government on this case. Sophie, you must be delighted with the Supreme Court ruling.
Well, absolutely. We welcome the Supreme Court upholding the Court of Appeal's decision that Rwanda is not a safe third country, and that asylum seekers sent from the UK to Rwanda would encounter a fundamentally defective system which would render them vulnerable to being returned to their countries of origin.
We did hear from Lord Howe at the end there that he did say something along the lines of, I'm just getting my page of the notes, he said that changes to the policy might make it possible for this policy to be lawful, but they've not been presented yet. I mean, I guess my question with that in mind is, are you already gearing up for the next fight on this policy, and do you expect some kind of changes from the government to try and make this work in future?
Well, what we've seen from the inception of this policy is a fundamentally defective asylum system in Rwanda. And we have made clear from the outset, and as supported by compelling evidence from the UNHCR, that the Rwandan asylum system would require wholesale change for it to have any hope of being safe and reliable. There is no quick and easy fix, and fundamentally the Supreme Court have found that this policy is not lawful and cannot be implemented.
And just in terms of the government, they will be very disappointed. You are very pleased. Do you think that they have any chance of reviving this policy, or do you think now it is effectively done?
Well, of course the government will be incredibly disappointed today, but this is a victory for the rule of law. The government cannot act with impunity. Nobody is above the law, and that includes the Home Secretary. This policy, we maintain from its inception, has been unlawful, cannot be lawfully implemented, and we can see no way in which the government can now alter it to make it lawful and to safeguard the fundamental rights of some of the world's most vulnerable individuals.
And just finally, just in terms of the government, there is a big movement within the Conservative Party that the solution to this is to withdraw from the ECHR. What's your view of that?
The European Convention on Human Rights was ratified by the UK, by Winston Churchill, in the aftermath of the horrors of World War II. It would be a damning indictment on this country were we to join Russia, Belarus in withdrawing from the European Convention on Human Rights. And of course, we hope that the government does not take such drastic steps in its game to weaponise immigrants in this country.
Sophie, can I just to wrap things up, I mean, you mentioned that you felt this policy was unlawful from the day it was brought in. That was 18 months ago, of course, by Boris Johnson and Priti Patel. I don't quite know how to word this question, but do you think they made your job not easy, but less difficult than it could have been? I mean, do you think that policy, when it was announced, was rushed? Have you had cases like this before, with perhaps so many areas for you to exploit as a lawyer to get the decision you want to?
I think what's so disappointing and shocking about this policy is that government officials warned from the very outset that there were real risks here, and the Home Secretary trenchantly ignored these warnings. She refused to listen to the warnings of the UNHCR. The UNHCR issued an unequivocal plea, and she also disregarded cogent evidence around the real risks to asylum seekers. So it is really disappointing that this court case has been necessary to finally restore justice.
Sophie, thanks so much for joining us. Much appreciated. Director of Duncan Lewis, a law firm that was fighting on behalf of refugees today and won that battle that the government's policy was unlawful. We're going to swap Sophie out now for Annette Elder again, our immigration expert. And Beth, in the meantime, it is worth pausing to reflect on this policy that's gone through 3 prime ministers, 4 home secretaries, was clearly rushed in its first announcement by Boris Johnson, pretty Patel in the first place. But successive home secretaries, successive prime ministers have continued to tie themselves to it, thus far totally unsuccessful.
And not just tied themselves to it, but amplified it. Now, the flip side of that is you could argue that when you look at small boats crossings, it really did begin to get like huge numbers only in the past 4 or 5 years. So arguably, if you're a prime minister, especially a conservative prime minister, where immigration is typically a very, very core policy area where your voters expect you to deliver, what option do you have but try to tackle the problem? I think the difficulty is that it's very easy to say stop the small boats, and it's incredibly hard to deliver that. It's a policy that doesn't just take a year or 2. It takes years. It involves working with other countries. It involves trying to discourage or stop people, the root causes why people are coming over. It involves breaking up the gangs. It involves deals with France, and Boris Johnson didn't have a great relationship with President Macron, did he? And the Prime Minister has all these levers, and he is trying to pull them all. But he made this the centrepiece. He made this the symbol of success, and it has been bogged down in the courts ever since. And the consequence of that is it looks to the public like they've cooked up a policy that isn't going anywhere, so it doesn't look very competent. And then within the parliamentary party, it's stoking divisions about where they should go next. And you heard, Victoria, the other lawyer, I've forgotten her name, I'm sorry.
Sophie,
I'm sorry,
and you were speaking to Tafiq before.
Well, you heard Sophie Lucas saying there, that she would not expect a government to pull out of a convention and be in the corner with countries like Russia and Belarus who've also pulled out of the European Convention for Human Rights. And that's where you can see the Prime Minister's probably at, especially with his new Foreign Secretary, David Cameron, and his new Home Secretary, James Cleverly. But by goodness, there's a group of backbenchers that think that this is an election, this is a battleground they should fight the election on. And I think Suella Braverman is clearly pull out of the ECHR is going to be a platform which she is going to campaign on quite prominently.
Let's bring back in Annette Elder, who you can see here, an immigration lawyer from the Law Society. Expand on that for us. What does pulling out of the ECHR actually entail, and how big a signal, positive or negative, would it send to the world?
So just picking up on that and speaking to the lawyers coming out just then, so the barristers, who heard the judgment when we couldn't really hear the detail of the judgment out here. What they're saying is one of the most amazing things about the judgment was that it was made clear that this is not just about breaches of the ECHR. It would be unlawful in ECHR terms for the policy to go ahead, but it also breached the Refugee Convention, the Trafficking Convention, possibly other conventions. So all of this will, become clear once we have the chance to read the full judgment. But so apparently it's very clear that withdrawing from the ECHR does not solve this problem.
And that goes back to what this senior Conservative, a former cabinet minister, was saying to me then, saying that if you think leaving the ECHR is your response to this, you've not made the judgment, you've not read the judgment, because it won't make any difference. I mean, the point is that politically now this has momentum within elements of the parliamentary party. Is this the next division, the next fault line within the parliamentary party about withdrawing from this?
Of course, it raises the question, Beth, whether now the Prime Minister tries to distance himself from the policy if there are so many complications to it, and instead try his focus, which is very much not stopping the boats, but saying his policies are working. It reminded the numbers, 2022, 46,000 crossings. Snapshot, the same point at this time last year, the crossings are down a third. Now, there's lots of factors at play. say, but he might instead try to point to his policies are sort of working if they haven't quite stopped the problem altogether.
Yeah, and that is exactly what he said last night after Suella Braverman published that excoriating letter, not just of him personally, but of his policy phase. I've just got a government response here, actually. Let's read it out. Prime Minister Rishi Sunak said, "We have seen today's judgment and will now consider next steps. It was not the outcome we wanted, but we have spent the last few months planning for all eventualities. We remain completely committed to stopping the boats." Crucially, the Supreme Court, like the Court of Appeal and High Court before it, has confirmed the principle of sending illegal migrants to a safe third country for processing is lawful. This confirms the government's view from the outset. He goes on to say illegal migration destroys lives and costs British taxpayers millions of pounds a year. We need to end it, and we will do whatever it takes to do so. He goes on, because when people know that if they come here illegally, they won't get to stay, then they will stop coming altogether, and we will stop the boats. Now, I think we're expecting a statement from the Home Secretary this afternoon, and I think that the Prime Minister is going to be holding a press conference this afternoon. So, Home Secretary, and we are going to be seeing a press conference from the Prime Minister later this afternoon. And I think within that, Wilf, what do we see? I mean, they've said sending illegal migrants to a safe third country for processing is lawful. That says to me, are they going to look at different deals with different countries? He says that we remain committed to stopping the boats. I think what we're getting now is we're going to hear what the Prime Minister's plan is.
Beth, you're
later.
so ahead of the curve here. Our producers are screaming at me to get to the response from Rishi Sunak, but Beth's already read it out, so we don't need to.
My bat phone is working on fire today.
For the repeated reminder. And in terms of the options here, one of the reasons we said there that the numbers have dropped was this returns policy with Albania. Albania was now considered a safe third country, but also the country of origin for a lot of these refugees. Are there lots more individual options there, or not really, because most of the other countries of origin that we're talking about probably won't ever be considered a safe country of origin? Explore that kind of option for the government for us.
Yeah. So, I mean, it's really important, I think, to bear in mind that stopping the boats is just never going to happen. There is no evidence, the government doesn't point to any evidence that deterrent policies like sending people to Rwanda actually impact on the number of arrivals. You know, the Home Office's own research doesn't support that these kind of deterrent policies are a factor in people reaching decisions about which country to claim asylum in. In terms of reasons why maybe numbers crossing the channel are down approximately 30% this year on the same period last year. Once you take out the Albanians, which was a very, distinct and quite unique kind of cohort of people for a short period of time, in fact, numbers are up. And, that was a very, they are a very specific group. And that was a returns policy. As Beth has kind of flagged, it's complex, and there is not one answer that is going to solve all of this. I mean, there are other factors. This year, the weather has been much worse. Over 90% of people who cross the channel in small boats have been claiming asylum because there was no real reason not to make yourself visible. If you have a very punitive thing like Rwanda, you're going to force people underground, and then they become very vulnerable, all of that kind of thing. And then there's just shifting kind of smuggling routes and that kind of thing.
I do just want to reconfirm what Beth already mentioned to you, the line from the Prime Minister, that he said this was not the decision that we wanted. But he did also say, of course, contrary to Suella Braverman's letter last night, that they spent the last few months planning for all eventualities. And as Beth already did tell us, a press conference will be held this afternoon, and the timing now of that has been confirmed, 4:45 p.m. for that press conference. Okay, so it raises the question, Beth, whether he'll escape much focus on this in Prime Minister's questions. I doubt it, suggesting to wait a little bit later in the day. Beth, as we sit here, how big a blow is this for the Prime Minister? A policy that he's tied himself to, but he didn't initially introduce, that there are huge complications with going the route that the right of his party wants to go. It's not as cut and clear as being the answer. And on a day, let's just mention, where one of his 5 pledges to half inflation, he received a massive bit of good news on.
Yeah, I think if you are in Downing Street now, you would argue, I would say this is a massive blow. What would they argue back? They would say, actually, the crossings are down by a third. I think we're going to hear that a lot today, that we've put a series of policies in place and we have time before the next election to show to voters that we are getting on with the job. But the reality is that they amplified this policy. They announced it to great fanfare. They've had rows in the courts. It's the visual, Suella Braverman went over to Rwanda and did filming there, going around some of the accommodation where failed asylum seekers would be sent, right? So they have amplified this policy. And I really think that they are going to have to try and find a way to pursue it and get it off the ground. I mean, I think the blow will be that, there's not going to be any visibility of any planes leaving any time soon. But I think the way the Prime Minister will probably argue it is that other countries such as Germany are following these sorts of policies. We are not out of step with what some other European countries are looking at, and we are going to persist with the Stop the Boats plan. And clearly he's having a press conference today because he wants to take back the narrative on this from Suella Braverman and from the right of the party that are now going to be agitating for him to take more drastic measures and probably lay out next steps. But it will be very interesting today later to see how the Prime Minister actually responds to some of those very personal criticisms in Suella Braverman's letter, because not only did she say that he'd broken promises, that he equivocated on this policy, that he didn't have a plan B, that they were going to back to square one. She also revealed that she had a deal with him written down where he agreed to sort a series of policies in order to win her back in to go in and be Home Secretary, which she said helped put him into number 10. So I think he's going to be asked not just on this policy, but a lot on Suella Braverman, what he did or didn't agree, and what these broken promises might be.
Well, we have had an action-packed morning here at the Supreme Court, and we are going to take a quick break, and we'll be back with all of the latest, of course, at the other side of it. The latest breaking news, by the way, we mentioned the Prime Minister's statement on all of this will be at 4:45 p.m. Of course, Prime Minister's questions precedes that at 12. And in between 12:30, the new Home Secretary, James Cleverly, will make a statement and answer urgent questions in the House of Commons. Lots more still to come on this decision, and more reaction from Beth and I from outside the Supreme Court here, where we heard the Supreme Court hand down a unanimous judgment, 5-0, to uphold the Court of Appeal's decision that the government's Rwanda deportation policy is unlawful. Sky News Today, back in just a couple of minutes.